Hello students, welcome to SRIRAM's IAS, welcome to this live class 50 most important topic. Although we have completed our 50 topics for Indian Polity, but there are few topics which are left. So we will be covering those few topics and it will be very handy for you for your upcoming examination, prelims examination on 25th of May 2025. So let's begin our class. The first topic is about the National Commission of Backward Classes. Now, why was it in news? Because of the inclusion and exclusion of OBC from the central list. This was in news, along with the issues of subcategorization, along with the issues of creamy layer. All these things, because of all these things, National Commission of Backward Classes was in news. So it recommends inclusion of 7 communities in the central OBC list for Maharashtra. Moving on, all these news which comes, why they become important? Because they are linked with some or the other static topic. Now this is directly linked with Article 338B of the Constitution. That simply means National Commission of Backward Class is a constitutional body. Although originally it was not a constitutional body, it became a constitutional body by 102nd Amendment Act, Constitutional Amendment Act. Okay, 102nd Constitutional Amendment Act. Similarly, National Commission for Scheduled Tribe. National Commission for Scheduled Tribe was also not there in the original constitution but was added later on by the 89th Constitutional Amendment Act. This was in 2003. Okay. So National Commission of Scheduled Caste was there in the original constitution. So it is important for us to understand the articles which are allotted to it. Article 338B for National Commission for Backward Classes. Article 338A, this was also inserted later on for the National Commission of Scheduled Tribes, and National Commission of Scheduled Caste is there in the original constitution under Article 338. So 330, you must remember these three are constitutional bodies. Earlier, National Commission of Backward Classes and National Commission of Scheduled Tribes were not a constitutional body, but it became the constitutional body after the 89th Constitutional Amendment Act and 102 Constitutional Amendment Act. You must remember this. So the constitutional status was granted by 102 Amendment Act in 18. What is the function of National Commission for Backward Classes? It safeguards OBC, okay, the other backward classes. It does everything related with OBC. The inclusion of any backward classes into the central list is done by the President after the advice made by the National Commission of Backward Classes. It also looks for the welfare of the backward classes. Grievance redressal and policy advice it gives. And the composition, there is a chairman, there is a vice chairman, and there are 3 members. Similarly, the same composition is there for National Commission of Scheduled Caste and National Commission of Scheduled Tribes. Power, it has the power of civil court and it reports to the President directly. Okay. In the Maratha reservation case also, its role was huge, that it was about to advise the President on inclusion or exclusion of a community in the central list. Moving on to the next topic. 47,000 complaints are filed with National Commission of Scheduled Caste. As we have seen, this was present in the original constitution under Article 338, National Commission for Scheduled Castes. And the complaint relates to land disputes. So this is also a body which looks after the welfare of the scheduled castes, which look after the grievances redressal of the scheduled castes. It is a very, very important body and it's a constitutional body and comes under Article 338. So Prevention of Atrocities Act also, it looks after this act. Now this act have been passed in 1989. It provides for the punishment if some crime is committed against the members of this scheduled caste community. It also provides for compensation by the state for the harm caused, physical harm or intellectual or mental harm caused. Recently there was a case where the years of research of two Dalit scholars who belong to the scheduled caste category was burned down in a home dispute. They approached the Supreme Court for compensation. So a great question came in front of Supreme Court whether the intellectual property, means the research paper and everything was the intellectual property, whether the intellectual property of two Dalit scholar can be considered as a physical damage or not. And Supreme Court said that it should be considered as a physical damage, that the physical damage done to the property, to the bodily integrity of a scheduled caste community member, then the central government pays the compensation. The government also has to pay the compensation if there is any loss of intellectual property of a member of scheduled caste community. So it's an important thing you must remember. It also looks under the reservation and welfare provisions, redresses the grievances related to caste discrimination. These are very important body. In one or the other way it tries to uphold Article 14 and Article 21 of the Constitution of India, right to equality and right to life and personal liberty. Because if these are not there, these bodies which looks after the welfare of the communities is not there, then the marginalization of these communities will start again. Or else we can look it in a very different angle, that whatever marginalized has been done, to undo that, these bodies are of great use. Okay. Moving on to the next thing. Amid NEET row, UPSC to revamp its exam system with new technology. So now UPSC is also one of the current affair here. So this Pooja Khedkar row which took place and the NEET scandal which took place, cheating can be done in the UPSC examination, not in the examination but while filing the papers, the caste papers or the papers related to the age of a person, physical handicapped, all the certificates which are there, and certificates can be made, this what we call it as fake certificates can be obtained from authorities and can be submitted to UPSC. Certificates related to caste, related to the income category, related to the physical handicapped. Now to streamline all this, and this Pooja Khedkar row which has happened should not happen the next time. The use of artificial intelligence and technology has been done by Union Public Service Commission. So now let us understand about Union Public Service Commission. It's a body which conducts exams in India, or all the top level exam. The exam for which you are preparing is conducted by UPSC for the All India services, for central services. If in future the All India Judicial Services comes in, the exams will be conducted by UPSC. It is a constitutional body under Article 315 of the Constitution. You must remember this. It's a very powerful body and it's a constitutional body under Article 315 of the Constitution. Recruitment is through open competitive exam, the exam for which you are preparing, advising the government on service matters, and it ensures meritocratic appointment. So the independence of UPSC is of paramount nature. If the chairman and the members of UPSC are not independent in taking their decisions, they can be manipulated by the political class. They can be manipulated by the economically well-placed people. And for that reason, some kind of independence has to be given, and Constitution ensures their independence through several things like fixed tenure. They can be removed before their tenure. They also have prohibition of removal except as per the Article 317. Article 317 provides several grounds and the manner in which they can be removed. They cannot be removed in any way on the whims and fancies of the political class. But there shall be a procedure which should be followed. There is a mechanism. Only if they did something wrong, if they are shows incapacity or are going against the Constitution, things like that. Budget charged on the consolidated fund of India. So it symbolizes integrity and efficiency in public administration. It's a current affair topic. It's a very important topic. Can be asked in your upcoming examination. You must study it well. Constitutionality of the electoral bond scheme. So electoral bonds. It was struck down by the Supreme Court recently in one of its judgment. So what is this electoral bond? Simply put, electoral bonds relates to the donation made to the political parties. There are many political parties in India. India is a multi-party democracy. Political parties form a very important part of the democratic system in India. The parliamentary form of government depends on the multi-party system in India, isn't it? And to run a political party, you also needs funding. Cannot be done without funding. And for funding, donations are needed. So there wasn't any transparent way for donations in the political parties in the past. So in 2017, a law was brought, a Finance Act was brought, although it was considered as a money bill and was passed by the, Lok Sabha without a proper scrutiny of the Rajya Sabha. It was criticized because of that, but anyway, electoral bond scheme was implemented. Now, all the political parties which have got at least 1% of votes, means, there must be some standing of the political party, some ground. Why should, or else, any political party, any person can make and register a political party with the Election Commission of India according to the Representation of the People Act, and then, can route black money through shell companies to a political party. So for that reason, to be eligible to get the electoral bond and donation through electoral bonds, it was necessary that the political party in India should at least get 1% of the votes. Now, if a political party is getting 1% of the vote, that is eligible for this scheme of electoral bonds. Now, what is electoral bonds? Again, so we are going to understand this with an example. If a person, let's say this is a person who wants to donate to a political party, and this is a political party here. So earlier what used to happen, this person used to go directly and donate to the political party, put the money inside the bank account of this political party. To avoid this direct thing, a scheme was brought. A scheme was very simple, that this person will not directly donate to the political party, but rather this person will go to the bank, preferably SBI, and will purchase a bond. That bond will be called as electoral bond. SBI is not going to distribute these bonds or sell these bonds throughout the year, but only 4 times in a year. That too 10 days, for 10 days each time. Okay, so in total, SBI will be selling these electoral bonds for about 40 days in a year. Now, in those 40 days, a person has to go and purchase that bond from SBI. They will be in the denomination of 1,000, 10,000, 1 lakh, 10 lakh, like this. And a person can purchase a bond of any denomination. Whatever amount of money the person wants to donate, the person can buy an electoral bond of that value. Now this person, once he buys the electoral bond, and now he has the electoral bond and he had submitted the money with the SBI. Let's say this person wanted to donate 10 lakh rupees to a particular political party. He has deposited 10 lakh rupees in SBI and got that bond of 10 lakh rupee. Now this person will go and give this bond to the political party. Okay. This person will directly go and give this bond to the political party. The political party has to redeem this bond within 15 days. Okay, the bond does not, in one or the other way, we can say, had the information of who is buying the bonds. So this became the very basis of why Supreme Court struck it down. Supreme Court struck it down because of the simple reason that it was infringing the Right to Information Act of the people. That the information which is required that who is donating to the political party was not available in the public domain. Okay, so this bond scheme which was there, which in a way it is just bonds are like promissory bonds, but promissory bonds have the information of who is buying the bond and to whom the bond is paid. But in electoral bonds, the information of who is buying the bond and to whom it is paid was not available. It was only available to SBI. Now the Supreme Court have directed the SBI in the case, when this matter went in front of the Supreme Court, it has directed the SBI to disclose the name of all the people who have donated to the political parties to the Election Commission of India. And then Supreme Court further directed the Election Commission of India to make the names public. Okay, so that was the story of electoral bond. As of now, the electoral bond are not there in the market. They have been struck down, and the donation to the political parties are going on as per the previous rules. So the electoral bond, they were introduced in 17 via amendments through a Finance Act. So some key legal changes were made. Exemption from disclosure under Companies Act and Representation of People Act. So this became the point of contention. The exemption of disclosure, which is against the right to information, which is provided to the citizen of India under Article 21 of the Constitution. Because of this, the electoral bond was struck down. Unlimited corporate donations were allowed. Foreign funding restriction diluted via FCRA amendment, Foreign Contribution Regulation Act amendment. So foreign funding restrictions were diluted. Huge amount of foreign funding was also allowed. Any citizen of India can donate, and also the non-citizens can also donate through this electoral bond. So critics argued that it violated Article 19 of the Constitution. Right to information also comes under Article 19 of the Constitution and promotes opacity. Article 21 also, right to life and dignity also, this article also gets covered by the right to information, you must understand. So the issues and the concerns: anonymity. Donor identities were hidden from public. It was violating right to know. Only the bank knew who was the one who purchased the bond, and then it was given. So the name of the person who is donating was not there in the public domain. And that was the reason why Supreme Court has struck this scheme down. Corporate dominance, removed the corporate donation cap. That means a corporate house or a person, a businessman can donate any amount to the political party, risking undue corporate political nexus. This was one of the bone of contention. Crony capitalism is already there. Then this corporate political nexus was going to be a huge setback for the democratic system in India. Lack of transparency, it contradicts the RTI norms and electoral integrity. And then money laundering risks were also there, that it also allowed the shell companies to donate without scrutiny. Shell companies can be foreign also. The contribution limits were diluted through FCRA Act. Now ethics, parliamentary conduct and the Indian MPs. So the ethics committee of the parliament, this is a very important committee of the parliament. It became a permanent committee of the parliament in 2015. Initially it was a standing committee, an ad hoc sort of a committee. It looks into the matters related with the ethical conduct of the members of the parliament, not only inside the parliament but also outside the parliament. If anything is done or said by the member of parliament which is considered unethical, an inquiry is done or inquiry is conducted by the ethics committee. Now while conducting the inquiry, it can also summon the member of parliament to its meeting. And the report of this inquiry has to be submitted to the speaker. has to be submitted to the chairman, either in the Lok Sabha or the Raj Sabha. So that is the power of the ethics committee, and it is very much needed. That was not a very ancient phenomena. I mean, that ethics committee did not start at the commencement of the constitution, but started to come in the practice later on, and especially became a permanent committee in 2015. So they operate in aid of Article 101 and 102. 101 talks about the vacation of seats, and 102 about the disqualification. So it aids Article 101 and 102 in one or the other way, we can say that. So that is what is ethics committee. It examines the complaints against the member of parliament, it formulates code of conduct, and it recommends disciplinary actions. So these are important aspect of ethics committee. Okay, moving on to the next topic. Stormy winter session ends with dismal output. So it is all about the parliament and the working of parliament, declining efficiency of parliament, declining productivity of parliament. And why this is happening? Because of frequent adjournments. Why frequent adjournments? Because of frequent protests. Instead of debating and deliberating on a subject, the member of parliament have found out a new way to either come into the well with postcards or start disrupting the sessions of the parliament or stage a walkout. So all these things does not help in deliberation or debate in the parliament. The parliamentary process is very pure and sacred and has to be followed in the right manner. Okay, and this public money is spent. Each minute, thousands and lakhs of rupees are spent for running the parliament in security, and so many other expenses are there. So, the expenditure of the public money, that is one concern. But parliament is there for a larger purpose, and it is unable to show its productivity in the recent time because of frequent disruptions, frequent protests, and frequent adjournments, which was not there in the past. I don't know why it feels as if the member of parliament does not enjoy debating in the house. Anyway, if a bill has to be passed because of the brute majority of the ruling party, it will be passed. Just shouting, protesting is not going to change the ground reality or the numbers in the house. But anyway, opposition plays its own role. Opposition plays a very important role in a democratic system, but opposition should not protest or disrupt the sessions of the parliament. Rather, they should be focusing upon deliberation and debate within the parliament. That is how people are going to respect them more. That is how people are going to value them more. They know more than us. Shortened sessions are there. Then lack of debate on bills. Some of the bills are passed without discussion. Also, this Rajya Sabha, this money bill route. If you declare, and who has the power to declare a bill as a money bill? The Speaker of the Lok Sabha. If the Speaker of the Lok Sabha declares a bill as a money bill, it doesn't have to go through the scrutiny of the Rajya Sabha, because the majority power when it comes to a money bill is held by the Lok Sabha. And in Lok Sabha, generally, not in this session, but the previous two governments, the majority in Lok Sabha was very brute. Okay, so that was another thing which was trying to surpass the the democratic value and the democratic procedures in the house, in the parliament. So dedicated time for opposition, these are some suggestions which can be implemented, that there should be some dedicated time for opposition. For your prelims exam, it is very important if you read article 107 to 122 which governs the legislative functions of the parliament. If you give dedicated time for opposition business, it will be, there is a question hour. Dedicatedly, the first hour of the start of the parliamentary session of the day, the opposition can ask questions. Okay, so there are mechanisms, but still a dedicated time for opposition business will help. Automatic expunction of the disorderly interruptions. Now the chairman or the speaker have the power to expunge the disrupted speeches and speeches which are made, which are beyond the time limit which is allotted or are not according to the democratic value or the ethical value of the country. Revival of pre-legislative consultations. So pre-legislative consultations are very, very important. If you bring a law in the parliament, disruption is bound to happen. But if that particular law which has been introduced in the parliament, if there is a deliberation in the pre-legislative stage, then it will be better. Then the disruptions are going to be far more less. So these are few advices which can be implemented. Strengthening deliberative democracy is essential for upholding constitutional governance. All these lines are very important for your mains examination. You can use it in introductions or in conclusions. Those are very important. So zero FIR, online police complaints. If you see section 154, that is very important. Section 154 of Criminal Procedure Code. In a way, it is police's obligation to file a FIR if you approach them. Now, sometimes police do not file the FIR. Many times the police try to ignore you, or many times the police just does not listen to the people who have reached to the police stations. So it is the obligation, and for better efficiency and the productivity of the criminal justice system, these two initiatives are of great use, zero FIR and e-FIR. Now everybody knows about e-FIR. E-FIR is simply an online FIR. Anything happens with you, you can file a FIR using your mobile phone and internet, and it reaches to the police station of the jurisdiction. Similarly, there is another thing which is called as zero FIR. Now, zero FIR is a mechanism where you can make a complaint or file an FIR in any police station throughout the country, irrespective of the jurisdiction. If, let's say, some crime has been committed in Delhi, but when you know about it, you are somewhere in Calcutta. So you can lodge an FIR in Calcutta in some police station. Later on, it will be sent to the police station of the jurisdiction where the crime was committed. So these FIRs, these zero FIRs and online FIRs are of great use for the efficient working of the criminal justice system in India. EFIRs enable online filing of cases, typically non-cognizable offences. They enhance access to public justice, of course it does. Promote victim-centric policing. So now to report a case and force the police personnel to work on that case is in the hand of the people. They can do it anytime through online FIR or zero FIR. Even when the police personnel is not listening to you, and if you file the FIR online, he has to listen to you. So the power is in the hand of the people now to promote the victim-centric policing, and it reduces procedural delays. Okay. So both stem from police's obligation under section 154 and reinforces constitutional protection under article 21 of the Constitution. Linking APAR ID with Aadhaar, a case of government circumventing a judicial ruling through administrative means. What is this APAR ID? We must have heard about the DigiLocker, but what is this APAR ID? Now the DigiLocker system is the online mechanism where you can, you know, sort of you can keep your driving license or your Aadhaar card or your PAN card or your certificates, the educational certificates and everything. But this APAR ID is related to the academic certificates which you have, academic credentials which you have. So it's a part of the National Digital Education Architecture under the National Education Policy of 2020. So this is the digitization drive of the government, that you can have all your academic credential in your hand, in your mobile phone, everywhere. Similarly, there was this DigiLocker also, that you don't have to carry the physical copy of your driving license or the physical copy of your PAN card. You can have that installed, issued by that particular institute. For example, PAN card, the issuing authority issues the PAN card, the digital PAN card, and you can show the digital PAN card or the digital driving license anywhere, and nobody can deny that under the DigiLocker thing. Similarly, there is this APAR ID. You don't have to carry your certificates everywhere. You can upload it in your mobile phone, in your APAR ID. If let's say you have to show your certificate to some authority, you can show it on your mobile phone also. If you click the photograph and then show it, it may not be admissible. But once through the APAR ID, the certificates, the educational certificates, 10th certificate, 12th certificate, degree certificate, mark sheets, they have been issued by the issuing authority, by the university, by the Central Board of Secondary Education or ICSE, or by the State Education Board. Now that is acceptable by the authorities. So that is what is APAR ID. It aimed at universal student registries from preschool to higher education. It ensures streamlined governance and educational mobility, supporting Article 21A and digital inclusion. So all these are the drives of the government. The digital drive of the government may be of some use to you for your upcoming prelims examination. So study, just know about this automated system. Now, power of pardon. India keeps it rare, the US does it more. So the power of pardon, some time back, the former President of the United States, Joe Biden, have given pardon in one of the case to his son, and this issue of pardoning power of the president has came up. So in India also, president and the governor, who are the sovereign powers, have the pardoning power. But there is a bit of a difference between the pardoning power which is used in India by the president and the governor and the pardoning power of the President of the United States. Under Article 72, the President enjoys the pardoning power, also the powers to remit, respite, reprieve, commute a sentence. Similarly, under Article 161, the Governor enjoys the same power. But there is a bit of a difference. Governor cannot pardon somebody for death sentence or for court martials. But the President of India can pardon anybody for offences under union law, for court martial sentences and for death sentences. This is usually done to correct the judicial wrong, to correct the judicial mistakes, and also to show compassion. Now when you say pardon, it simply means to acquit the person. The person just walks out, walks away from the punishment, and that is the power which is given to the President of India by the Constitution. Now comparing it with the power which the President of the United States have, Article number 2 of section number 2 of the Constitution of the United States wastes this power in the hand of the President of the United States. And this power is a near absolute power. Okay, this is a near absolute power. He can use it whenever he wants upon anybody he wants. The US President. Whereas the president in India and the governors in India act on the aid and advice of the Council of Ministers. They cannot do anything on their own. It's not the absolute power of the governor or the president to show pardon or to issue pardon orders. So that's the difference which you must understand. The Indian president acts on the advice of the Council of Ministers during the pardoning thing. This was a Maru Ram case, which was a very important case. And the US president exercises personal discretion. This is the difference. It's a very basic difference which you should understand between the pardoning power of the US president and the Indian president. Important environmental law. Now, Article 21 of the Constitution has become a mammoth, has taken a mammoth, composition. It has become very huge. Many of the laws, many of the rights, such as right to bodily integrity, right to privacy, right to marry anybody of your choice, right to information, all these things, although not explicitly written under Article 21 of the Constitution, has been included in Article 21 of the Constitution by the interpretation of the Supreme Court, the interpretation of Article number 21. Because Supreme Court says that right to life and personal liberty simply means having a life which the person lives with dignity. And environment and climate change, they are concerns for human being. So to have a right against climate change is linked with your dignity, and hence it is the right under Article 21 of the Constitution of India. In the recent judgment in 2023, right against climate change was added under the ambit of Article 21 of the Constitution of India. Okay. So, right to clean environment, that is also included under Article 21. Intergenerational equity, that is also included under Article 21. Sustainable development, that is also included under Article 21. And right against climate change or right to climate protection is also added under Article 21. These are rights, fundamental rights given to the citizens. Now, courts increasingly treat climate stability as an extension of human dignity and public trust doctrine, blending directive principles of state policy such as 48A and the duties under 51G with enforceable right. What is these enforceable right? Which are justiciable. It simply means fundamental rights. So the issue of environment is not only present in the fundamental rights under Article 21, but also under the directive principle of state policy under Article 48A and the duties under Article 51AG, where the citizens have the duty to protect the environment, flora, fauna and wildlife. Important environmental law orders judgment passed, we have already done this, I think. So now, this is another thing, inheritance tax. So, you know what is inheritance? Inheritance is simply when the father transfers or the grandfather transfers their property, the family property, to the heir, to the son, or also to the daughter now. We are not living in an era where daughters are not given the equal rights. They are given the equal rights also in inheritance, in different personal laws of different religions also. So, this inheritance which is done, for example, there was a property or a land or some, there are huge properties belong to people and they want to give it to their son, they want to transfer it to their sons and daughters. Now that is what is inheritance. The property which was holded by your, it's also called as the parental property, which is holded by your forefathers, is coming down and is handed over to you, and you are expected not to sell it but to hand over to your next generation. You also have the right to sell it if you want, but usually in India, people are emotionally linked with their inherited properties. People are linked with their parental properties and usually they do not sell it. So if it is a parental property and has been transferred in your name, that is what is inherited property. Now, this inherited property, no tax is imposed on this. On the contrary, if you buy something, if you buy a piece of land and then you sell that piece of land after 10 years or after 5 years, the amount of money which you have gained, capital tax is imposed on that money. Whatever you may have earned, capital tax is imposed on that money. But inheritance tax is not there in India. But there have been debates and deliberations to impose the inheritance tax also. India repealed estate duty in 1985. Currently, inheritance is tax free, though capital gain tax apply to asset transfer. So we have already seen the difference between capital gains and inheritance. Capital gain can happen anywhere. See, the transfer can happen anywhere. You can buy from an unknown person, but the inheritance only happens in family. Your father transfers the land or the property in your name. That is the parental property. That's called inheritance. You are the heir to that property. So argument in favor are that it reduces inequality. That simply means if you impose the inheritance tax, it will reduce inequality in the society. And there will be funding for social scheme, because the amount of money which will be earned by the government through inheritance tax is going to be huge, and it can be used in the social service or welfare schemes in the country. Argument against is it is an administrative burden. Through the robustness of this inheritance tax, because everywhere this happens, so administratively speaking it will become a burden, although it will not be that a big burden, because other kind of things also happen where the government collect taxes, and capital flights and tax evasions will be there. So if your property which your father wants to transfer, this is the parental property, and the father wants to transfer this to an heir, then let's say if this property costs 1.5 crore, the father is only going to tell that this property is around 80 lakh, so that the person has to pay less tax. So all these things, tax evasion and capital flights, that will be the other problem if the inheritance tax is implemented. Any reintroduction would require a comprehensive legal framework under Article 265, which is the tax power of the government. India restores diplomatic immunity to Canadian province trade representative. So diplomacy and the diplomatic immunity is of great use. Reciprocity is one of the principle which is applied and which is practiced. That simply means that you give immunity to our diplomats in your country, we will give protection and immunity to your diplomats in our country. That is the basic principle on which the diplomatic immunity works. Diplomats, the American or the British diplomat or the Bangladeshi diplomat or other diplomats from different countries who are living in India, they have some kind of immunity. They have immunity from civil cases and criminal cases. The host state for all the diplomats who are living in India, so India becomes the host state. Host state must ensure protection of diplomatic premises and personals. So whoever living in the high commissions or whoever the staff of that particular country which are living in the embassies of that country, the protection of the premises and the protection of the personals living inside that is the duty of the host country. If you go to Chanakpuri area in Delhi, you will see so many embassies and high commission. The protection of that area, the protection of embassies and the people living inside that is upon the India state. Similarly, our diplomats which are living in different countries, their security is in the hand of that country. And of course, immunity is given. Civil immunity and criminal immunity is given. So if let's say the United States of America provides immunity to our diplomats, we are going to provide immunity to their diplomats also, and it will be reciprocal. Let's say they decreases the immunity or the standards of immunity, then we are not liable. We are also going to decrease the standards of immunity. But there is also a law through which all these things works. There is a convention, Vienna Convention on Diplomatic Relations 1961. India has ratified it, and through this convention the diplomatic immunity is given to all the countries, all the diplomats living in different countries. Now there is this violation of personality right. This is another category of rights which are in news nowadays, included in Article 21 also. What is this personality right? Having control over your name, having control over your voice, having control over the way you walk and talk and everything, so that your personality and the traits of your personality cannot be used without your consent, without your permission in any ad or any film. That is what is called personality rights. So personality rights refer to the right to control commercial use of one's identity, such as name, image, voice, likeness. In India, it is protected as an extension of Article number 21, right to privacy, Article number 19, right of expression, and a tort law where your identity can be misrepresented. So this misrepresentation should not happen, and the Indian law protects the personality of a person. The traits of the personality of a person cannot be used against their consent. So this is one new category of fundamental rights which is emerging, and although courts have not said anything, but there is also a landmark judgment such as ICC Development versus RV Enterprises, and the recent celebrity cases have clarified the contours of these rights. Court often balance them with journalistic freedom and public interest. If a journalist, let's say, goes and takes a photo or does something which catches the trait of a particular personality, now that will be allowed. Or else what is the use of a journalist? Why are you becoming a celebrity if you don't want to come into the limelight? So these things have to be balanced. Similarly, just because you are a celebrity, everybody can use your personal trait. Now that is also not good. Several, these ads, the fake ads are run, or even the good advertising companies use the name and the voice of several celebrities without their consent in the ads. That is also not acceptable and also not permissible. Don't forward cases of those covered under CAA. Now we are going to read about the Foreigners Tribunal. This is a very important thing, Foreigners Tribunal, and this is working in Assam, although it has to be implemented throughout the country, but as of now this is working in Assam. It's a quasi-judicial body constituted under the Foreigners Act of 1946. It has some key functions. What are the key functions? It determines whether the person is a foreign national or not. It sees through all the ways and the means and the procedure whether the person is the Indian citizen or not, and if he is not the Indian citizen, then the foreign tribunals report this to the police in order to deport that person to the country from which he has originated. Review cases referred by border police or NRC authorities. Now this is another key function of the Foreigners Tribunal. It provides the individuals the right to representation and appeal. So this has came into news because of the CAA, the Citizenship Amendment Act of 2019, and the recent rules which were made in 2024. Now CAA, you must be knowing, it gives the Indian citizenship, a fast track Indian citizenship to all the persecuted minorities from 3 different countries which are the neighbors of India. The 3 different countries are Pakistan, Afghanistan and Bangladesh. And the persecuted minorities are Hindus, Sikh, Christians, Parsis, Buddhists and Jainism. So all these 6 communities from 3 different countries, if they are persecuted minority and they can show some proof of persecution in these 3 countries, they can come to India and become the citizen of India within very less time. All the people who have entered India belonging to the persecuted minorities and belonging from these 3 countries who have entered India before 2014 were already given the citizenship of the country. So the amount of time required for naturalization to become the citizen of India was reduced to 5 years. So foreigner tribunals, now these are implemented especially in Assam. Why? Because Assam is dealing with the problem of illegal migration from Bangladesh. So it becomes paramount to pinpoint who are the citizens of India and who are the outsider, and that work is done by the foreigners tribunal. Press freedom of India rapidly declining. So there are data which is showing that the press freedom of India is declining rapidly. The data or the report is given by the Reporters Without Borders. There are also Doctors Without Borders. Similarly, there are Reporters Without Borders, which measure the media freedom based on pluralism, transparency and safety. So what are the challenges to press in India? Arbitrary arrest of journalists, we have seen. Journalists are sometimes arbitrarily arrested without a proper ground. Then they are kept in jail for a long period of time, and after the intervention of the court, they are acquitted. Now these kind of things, in one or the other way infringes upon the freedom of press. Okay. Also, the open-minded journalists were shot dead in the recent past. There were so many instances. Internet shutdown. That is another thing, because the media is not only limited to the mainstream media or the news channels. Today, Twitter or X, Facebook, all these online media, the social media platforms forms a very important part of media. So internet shutdowns directly impact this social media, where the people are journalists, where the people are reporting from the ground. Threats to press independence. So Article 19 guarantees freedom of speech, but it is subjected to reasonable restrictions. Sovereignty, security, public order. These are the reasonable restrictions. Upholding media freedom is essential for democratic disclosure. We all know this. The only problem is that we have to implement it. Okay. Now, this is going to be the last topic, Central Consumer Protection Authority. Now, Central Consumer Protection Authority have came up with new things, new advertising guidelines for consumer awareness. So, many things have been sold to you, sold to everybody, and advertisements have been done. Sometimes the advertisement does not tell the real nature of the product which they are selling. For example, some advertises show the junk food as a very nutritious food. So that is not a good thing. It's a sort of fake information which is being circulated through advertisement. And against these kind of information, new advertising guidelines and consumer awareness, consumer awareness, to improve the consumer awareness, new advertising guidelines have been issued by the Central Consumer Protection Authority. Now this authority is a very important authority which works for the welfare of the consumers in India. So these rules seek to regulate misleading and surrogate advertisement. One of the example which I gave you just now, where the fast food is shown as a very nutritious food, and also sometimes when cartoons are coming on television, usually children are watching them. Different kind of advertisement come which can impact the mind of the young people, which can impact the mind of the children. That is also not allowed under the guidelines. Mandatory disclosures and paid promotion for social media influencers. So what kind of disclosure is done? That if they are making advertise for some product, the nutritional value of that product has to be disclosed. Along with it, if a social media influencer have taken money or have been paid to make an ad, for the circulation of this particular product, whatever product it may be, then the influencer has to tell that I have been paid for the promotion of this particular product. That is what is disclosure means there. Penalties under the Consumer Protection Act of 2019. So what does this new advertisement guidelines do? It enhances the informed consumer choices and transparency. So in one way, Article 38 of the Constitution, which is the directive principle of state policy, relates to the social welfare, is directly linked with this new advertising guidelines, which protect the people from bad choices they can make through the fake advertisement. And also Article number 19. So this was it. Thank you very much for joining me in this class, and the topics of Indian polity are completed now. We have done many topics of Indian polity which will be of use for your upcoming examination. We have also linked it with these static topics which will be of great use to you. Thank you very much for joining me. Keep watching this video. Keep watching our other videos for your welfare, for your